The following special report is part of the program Líderes del Futuro, which airs on KBBF.org every Thursday from 5 p.m. to 7 p.m. Pacific Time. Politics in the United States in 2024 are heavily focused on the conversation around immigration. It is important that we educate ourselves about what is happening and what the Republicans' plan is if they win the White House and Congress in the November 2024 elections. The problem for undocumented people is that they do not know, and to some extent do not want to know, what negative changes could happen starting in January 2025 if the Republicans win. This includes the elimination of DACA, the U visa, the T visa for victims of human trafficking, concentration camps at the border, and a focus on detaining people at their jobs to begin the deportation process. The intention of providing the following information is to educate the community about Project 2025. This section will focus on the Department of Homeland Security and the conservative idea of what should happen with immigration, immigrants, and refugees. This is a section that is part of a document over 900 pages long that dictates what should happen and when. The biggest concern is that, although the plan is available to everyone, few people are paying attention. The following comes directly from the section on the Department of Homeland Security, which was written by Ken Cuccinelli. Primary recommendation. Our primary recommendation is that the President pursue legislation to dismantle the Department of Homeland Security. After 20 years, it has not gelled into one Department of Homeland Security. Instead, its various components' different missions have outweighed its decades-long attempt to function as one department, rendering the whole disjointed rather than cohesive. Breaking up the department along its mission lines would facilitate mission focus and provide opportunities to reduce overhead and achieve more limited government. In lieu of a status quo Department of Homeland Security, we recommend that U.S. Customs and Border Protection be combined with Immigration and Customs Enforcement, U.S. Citizenship and Immigration Services, the Department of Health and Human Services Office of Refugee Resettlement, and the Department of Justice, Executive Office for Immigration Review and Office of Immigration Litigation into a standalone border and immigration agency at the cabinet level, more than 100,000 employees, making it the third largest department measured by manpower. All of the remaining supporting components could be dismantled because their functions already exist in the moving components as well as the receive negation-ing departments. Cutting these costs would save the American taxpayers significant sums, unless and until this dismantling recommendation is pursued and achieved. However, Department of Homeland Security will statutorily continue to exist, and it needs many reforms. Accordingly, we now turn to recommended changes in Department of Homeland Security as it exists now. Mission Statement. The Department of Homeland Security protects the American homeland from and prepares for terrorism and other hazards in both the physical and cyber realms, provides for secure and free movement of trade and travel, and enforces U.S. immigration laws impartially. Overview. The Department of Homeland Security was created in the aftermath of the terrorist attacks of September 11, 2001, and subsequent mailings of anthrax spores. The Homeland Security Act of 2002, which created the department, states that Department of Homeland Security's primary mission is to prevent terrorist attacks within the U.S., reduce the nation's vulnerability to terrorism, minimize the damage from and assist in the recovery from any terrorist attacks, prepare and respond to natural and man-made crises and emergencies, and monitor connections between illegal drug trafficking and terrorism, coordinate efforts to sever such connections, and interdict illegal drug trafficking. Unfortunately for our nation, the federal government's newest department became like every other federal agency, bloated, bureaucratic, and expensive. It also lost sight of its mission priorities. Department of Homeland Security has also suffered from the left's wokeness and weaponization against Americans whom the left perceives as its political opponents. To truly secure the homeland, a conservative administration needs to return the department to the right mission, the right size, and the right budget. This would include reorganizing the department and shifting significant resources away from several supporting components to the essential operational components. Prior negationizing border security and immigration enforcement, including detention and deportation, is critical if we are to regain control of the border, repair the historic damage done by the Biden administration, return to a lawful and orderly immigration system, and protect the homeland from terrorism and public safety threats. This also includes consolidating the pieces of the fragmented immigration system into one agency to fulfill the mission more efficiently. The Cybersecurity and Infrastructure Security Agency is a Department of Homeland Security negation component that the left has weaponized to censor speech and affect elections at the expense of securing the cyber domain and critical infrastructure, which are threatened daily. A conservative administration should return Cybersecurity and Infrastructure Security Agency to its statutory and important but narrow mission. The bloated Department of Homeland Security bureaucracy and budget, along with the wrong priorities, provide real opportunities for a conservative administration to cut billions in spending and limit government's role in Americans' lives. These opportunities include privatizing TSA screening and the Federal Emergency Management Agency, National Flood Insurance Program, reforming Federal Emergency Management Agency emergency spending to shift the majority of preparedness and response costs to states and localities instead of the federal government, eliminating most of Department of Homeland Security's grant pro-negation grants, and removing all unions in the Department for national security purposes. A successful Department of Homeland Security would secure and control the border, thoroughly enforce immigration laws, correctly and efficiently adjudicate immigration benefit applications while rejecting fraudulent claims, provide states and localities with a limited federal emergency response and preparedness, secure our coasts and economic zones. Office of the Secretary, soft closure of unnecessary offices. Pending a possible presidential detaining sign to shrink or eliminate Department of Homeland Security itself, the next administration will still have the obligation to protect the homeland as required by law. The Secretary therefore can and should use his or her inherent, discretionary leadership authority to soft close ineffective and problematic corners of the department. While those corners are to be determined, the Secretary could shift personnel, funding, and operational responsibility to mission-essential components of the department, including the Office of the Secretary itself. This effort not only would make the department more efficient, but also would support a legislative move to shrink or dismantle the department by showing that the agency can fulfill national security critical functions without its current, bloated bureaucracy. Compliance for grants and other federal funding. The next administration should take steps to restore lawfulness and integrity to the department's massive regimen of federal grant programs, most of which are managed and distributed by the Federal Emergency Management Agency. The Secretary should direct Federal Emergency Management Agency to ensure that all Federal Emergency Management Agency issued grant funding for states, localities, and private organizations is going to recipients who are lawful actors, can deem in negation straight that they are in compliance with federal law, and can show that their mission and actions support the broader Homeland Security mission. All applicants and potential recipients of such grant funding should be required to meet certain pre-negation conditions for eligibility, except for receipt of post-disaster or non-humanitarian funding, or should simply be considered ineligible for funding. Such preconditions should include at least the following: certification by applicants that they comply with all aspects of federal immigration laws, including the honoring of all immigration detainers. Certification by applicants that they are both registered with E-Verify and using E-Verify in a transparent and non-evasive manner. For states and localities, that would include certification that all components of that government, and not just the applicant agency, are registered with and use E-Verify. If the applicant is a state or locality, commitment by that state or locality to total information sharing in the context of both federal law enforcement and immigration enforcement. This would include access to Department of Motor Vehicles and voter registration databases. Non-use of discretionary guest worker visa authorities. To stop fatuously negating the availability of cheap foreign labor in order to support American workers, particularly poor and middle-class American workers, and follow congressional intent, the Secretary should explicitly cease using at least 2 discretionary author negationities as part of his or her broader effort to support American workers. The Secretary should make it clear that he or she will not use the Secretary's existing discretionary authority to increase the number of H-2B, seasonal non-agricultural, visas above the statutorily set cap. The Secretary should not issue any regulations in support of the H-2 eligible country list, the effect of which would prevent favoring certain foreign nationals seeking an H-2 guest worker visa based simply on their nationality. Restoration of honesty and transparency. The Secretary should use his or her inherent authority as leader of the department to follow up with congressional and other partners to disclose information and provide the transparency that has been obstructed during the Biden administration. The Secretary should proceed from the assumption that congressional inquiries and public information requests were unfulfilled, and then seek to fulfill them. Replacement of the entire Homeland Security Advisory Committee. The Secretary should plan to quickly remove all current members of the Homeland Security Advisory Committee and replace them as quickly as is feasible. U.S. Customs and Border Protection. If all immigration agencies are not merged, including U.S. Citizenship and Immigration Services and Department of Health and Human Services Office of Refugee Resettlement, then an appropriate third alternative would be to consolidate Immigration and Customs Enforcement and Customs and Border Protection to form a combined Border Security and Immigration Agency. This would into negation great critical interdiction, enforcement, and investigative resources, enhancing coordination and refocusing collective efforts on the vast and complex cross-border DACA threats impacting our nation's health, safety, and national security. It would also simultaneously add efficiencies to our nation's capacity to facilitate lawful trade and travel. The Border Security and Immigration Agency should establish clear mission requirements, responsibilities, and mandates under existing law regarding the persistent need for and utilization of U.S. military personnel and resources to assist Border Security and Immigration Agency with increasing whole-of-government efforts and long-term strategy to secure our nation's borders effectively. In addition, appropriate elements within the newly created Border Security and Immigration Agency should be designated as part of the U.S. national security and intelligence community. A conservative administration should eliminate any prohibitive guidance, direction, or mandate from Department of Homeland Security or the administration that curtails or limits Customs and Border Protection from publishing detailed border security and enforcement data not impacting intelligence, interdiction, and investigative operations, methods, or sources. Department of Homeland Security should issue a regulation mandating that Customs and Border Protection publish accurate and timely border security data, readily available to the public, on a regular basis that avoid White House and Department of Homeland Security leadership review and approval. The White House should grant the authority for Customs and Border Protection and Department of Homeland Security executives to utilize component aviation assets under the Office of Air and Marine. Customs and Border Protection and Department of Homeland Security have worldwide missions with personnel and facilities that are deployed across the globe and in every state in the U.S. with a Customs and Border Protection workforce alone of more than 60,000 people, 240,000 plus for Department of Homeland Security, encompassing more than 1,000 sea, land, and airports. It is essential that the Commissioner, Deputy Commissioner, Secretary, and Deputy Secretary can travel efficiently to facilities to maintain appropriate situational awareness across the department's vast mission set and interact with the expansive workforce. Although Customs and Border Protection operates one of the largest aviation components of any domestic U.S. law enforcement agency, executives are prohibited from utilizing the agency's aviation assets to facilitate official travel. Executives are required to fly on commercial airlines, and this requirement significantly limits their ability to have classified communications and takes them offline for extended periods of time. Border Patrol and Office of Air and Marine should be combined within Customs and Border Protection. Border Protection has more than 20,000 personnel, and Office of Air and Marine has approximately 1,800. Office of Air and Marine's assets are dedicated in support of border protection operations the vast majority of the time, yet redundant approved negation ALS strategies and independent hierarchical commands serve as impediments to efficient and practical resource deployments. Customs and Border Protection should restart and expand use of the horseback-mounted Border Patrol. As part of this announcement, the Secretary should clear the records and personnel files of those who were falsely accused by Secretary Alejandro Mayorkas of whip negation ping migrants and issue a formal apology on behalf of Department of Homeland Security and Customs and Border Protection. The Secretary should combine the Office of Trade and Trade Relations with the Office of Field Operations. The Office of Trade is the smallest of Customs and Border Protection's components, and its operational counterpart, Office of Field Operations, has a workforce of more than 30,000. Office of Trade's function is interwoven with that of its Office of Field Operations operational counterpart. Combinating Office of Trade with Office of Field Operations would achieve streamlined operations and increase Office of Trade's capacity and capability by leveraging Office of Field Operations' expansive resources. Customs and Border Protection, Immigration and Customs Enforcement, and U.S. Citizenship and Immigration Services all have authority to issue notices to appear to removable aliens in their presence, which begins removal proceedings. In most instances, Customs and Border Protection should turn illegal aliens over to Immigration and Customs Enforcement for detention, and Immigration and Customs Enforcement can then issue any needed notice to appear. Customs and Border Protection should issue notice to appears only in limited situations for humanitarian reasons, such as medical emergencies. In addition, Customs and Border Protection should eliminate use of notices to report altogether. Customs and Border Protection's established national standards of transport, escort, detention, and search have been widely interpreted and expanded by lower courts. This has resulted in unrealistic and differing detention standards for Customs and Border Protection facilities based on the jurisdiction within which they fall, negatively impacting operations. Immigration and Customs Enforcement has suffered similarly. A single nationwide detention standard should be codified that prevents individual states from mandating that federal government agencies adhere to widely expansive and ever-changing sets of standards. Such standards should allow the flexibility to use large numbers of temporary facilities such as tents, The annual costs associated with establishing and maintaining temporary fossil negationalities to address the flow of illegal migration and associated care, transportation, and processing are prohibitive, and Customs and Border Protection's budget is inadequate. Customs and Border Protection is forced to forego critical mission essential endeavors to fund the additional associated costs. Often this requires the reprogramming of funding at the Department of Homeland Security level, which has a negative impact on other Department of Homeland Security components' operations. This predictable cost that has to be paid from existing Customs and Border Protection and Department of Homeland Security funding levels reduces Customs and Border Protection's operational readiness and ability to accomplish its diverse and critical missions to protect the American people. The next president should request a realistic budget that fully pays for these costs. Increased funding is needed for Border Protection to hire additional support personnel, which would relieve uniformed Border Protection agents from administrative duties associated with processing aliens and allow them to return to their national security mission. Congress should increase funding for facility upgrades at strategic land ports of entry, including expanding state-of-the-art technology such as non-intrusion negation SIVE inspection equipment. Today, the cartels exploit the aging facilities and lack of adequate technology to smuggle illicit drugs, contraband, and more successfully through our nation's ports of entry.
U.S. Immigration and Customs Enforcement.
Needed reforms. Since the formation of Department of Homeland Security, Immigration and Customs Enforcement has increasingly been tasked with auxiliary missions that have little or nothing to do with either immigration or customs enforcement. To return Immigration and Customs Enforcement to its primary mission, any new administration that wishes to restore the rule of law to our immigration enforcement efforts should order Immigration and Customs Enforcement to stop closing out pending immigration cases and apply the Immigration and Nationality Act as written by Congress. The Biden administration closed out tens of thousands of immigration cases that had already been prepared and were slated for expedited removal processing or hearings before the U.S. Immigration Court. This misguided action constituted an egregious example of lawlessness that allowed thousands of illegal aliens and other immigration violators to go free in the United States. Direct Immigration and Customs Enforcement to stop ignoring criminal aliens identified through the 287G program. Ultimately, Congress should prevent Immigration and Customs Enforcement from ignoring criminal aliens identified by local law enforcement agencies that are partners in the 287G program. However, before congressional action, Immigration and Customs Enforcement should be directed to take custody of all aliens with records for felonies, crimes of violence, driving under the influence, previous removals, and any other crime that is considered a national security or public safety threat as defined under current laws. Eliminate TNU visas. Victimization should not be a basis for an immigration benefit. If an alien who is a trafficking or crime victim is actively and significantly cooperating with law enforcement as a witness, the S visa is already available and should be used. Pending elimination of the TNU visas, the Secretary should significantly restrict eligibility for each visa to prevent fraud. Issue clear guidance regarding detention and bond for aliens. Thousands of illegal aliens are allowed to bond out of immigration detention only to disappear into the interior of the United States, where many commit crimes and many others disappear, never to be heard from again. This occurs primarily because of poorly worded bond regulations, contradictory bond policy memoranda, and poor practices for managing released aliens and the Alternatives to Detention program, which requires significant reform. Prioritize national security in the Student and Exchange Visitor Program. Immigration and Customs Enforcement should end its current cozy deference to educational institutions and remove security risks from the program. This requires working with the Department of State to eliminate or significantly reduce the number of visas issued to foreign students from enemy nations. Most of the foregoing can be accomplished rapidly and effectively through exec negation action that is both lawful and appropriate. Additionally, Immigration and Customs Enforcement should clarify who is responsible for enforcing its criminal and civil authorities. It should also remove self-imposed limitations on its nationwide jurisdiction. Homeland Security Investigation Special Agents in the 1811 series should enforce Title 8 and 18 crimes as the biggest part of their portfolio. Alien smuggling, trafficking, and cross-border crime as defined under Title 8 and Title 18 should be the focus of Immigration and Customs Enforcement operations. The role of Immigration and Customs Enforcement deportation officers should be clarified. Immigration and Customs Enforcement and removal operations should be identified as being primarily responsible for enforcing civil immigration regulations, including the civil arrest, detention, and removal of immigration violators anywhere in the United States, without warrant where appropriate, subject only to the civil warrant requirements of the Immigration and Nationality Act where appropriate. All Immigration and Customs Enforcement memoranda identifying sensitive zones where Immigration and Customs Enforcement personnel are prohibited from operating should be rescinded. Rely on the good judgment of officers in the field to avoid inappropriate situations. To maximize the efficient use of its resources, Immigration and Customs Enforcement should make full use of existing expedited removal authorities. The agency has limited the use of expedited removal to eligible aliens apprehended within 100 miles of the border. This is not a statutory requirement. New policies.
U.S. National security and public safety interests would be well served if Immigration and Customs Enforcement were to be combined with Customs and Border Protection and U.S.
Citizenship and Immigration Services, as mentioned above. Additionally, Immigration and Customs Enforcement and Homeland Security investigations, along with Customs and Border Protection, should be full participants in the intelligence community. The use of Blackie's warrants should be operationalized within Immigration and Customs Enforcement. These civil search warrants are commonly used for worksite enforcement when agents have probable cause that illegal aliens are employed at a business. This would stream negation line investigations. Safeguarding Americans will require not just securing the border, but continuous vetting and investigations of many aliens who exploited President Biden's open border for potentially nefarious purposes, including some Afghan evacuees sent directly to the U.S. during America's disastrous withdrawal from Afghanistan. Budget. Congress should mandate and fund additional bed space for alien detainees. Immigration and Customs Enforcement should be funded for a significant increase in detention space, raising the daily available number of beds to 100,000. Congress should fund Immigration and Customs Enforcement for at least 20,000 enforcement and removal operations officers and 5,000 Office of the Principal Legal Advisor attorneys.
U.S. Citizenship and Immigration Services.
U.S. Citizenship and Immigration Services is the agency tasked with administering the legal immigration and certain temporary visa programs. Needed reforms.
Since January 2021, U.S. Citizenship and Immigration Services' priorities have been misaligned, and this has transformed it into an open borders agency, ignoring the critical role that it plays in national security, public safety, and safeguarding the integrity of our immigration system. U.S. Citizenship and Immigration Services should be returned to operating as a screening and vetting agency.
Regulatory efforts have focused on easing asylum eligibility in a manner that is guaranteed to exacerbate asylum fraud as people surge at the border. Emphasis also has been placed on removing legal barriers to immigration, such as the use of public benefits. These actions violate statutes, erode congressional intent, and provide a significant magnet for continued illegal immigration.
Additionally, U.S. Citizenship and Immigration Services resources have been misappropriated to focus more on creating and expanding large-scale parole and temporary status programs that violate the law and are otherwise contrary to congressional intent instead of negating on a more secure and efficient process for those who are seeking benefits.
The ever-increasing number of applications filed has made it difficult to vet applicant negations adequately for eligibility, fraud, and specific national security and public safety problems. The Fraud Detection and National Security Directorate is currently a small directorate with assigned officers reporting through the chain of command in the field, and this has led to stovepiping, lack of coordination in national policy, and inconsistencies throughout the agency. To prioritize vetting and fraud detection and National Security Directorate should undergo a structural shift focused on direct reporting from the field to headquarters, reclassification of leadership, and Fraud Detection and National Security Directorate directives taking negation over those of other component entities. Correcting the current misalignment of agency priorities and resources should begin with this primary shift in focus to vetting and fraud detection. These actions would reform the agency, returning it to its screening and vetting mission in protecting the homeland. Other structural changes should include re-implementation of the U.S. Citizenship and Immigration Services Denegation Oralization Unit, an effort to maintain integrity in the system by identifying and prosecuting criminal and civil denaturalization cases, in combination with the Department of Justice, for aliens who obtain citizenship through fraud or other illicit means.
Additionally, U.S. Citizenship and Immigration Services should create a criminal enforcement component within the agency to investigate immigration benefits fraud under Title VIII, perhaps requiring additional legislative and regulatory authorities for the negationsers themselves, and to prosecute cases through Special Assistant U.S. Attorney with substantive knowledge in the field.
Particular attention should be given to addressing increasing incidents of forced labor trafficking in temporary work visa programs.
While the Biden regulatory agenda has focused on at least two major rules, the credible fear rule and the public charge rule, U.S. Citizenship and Immigration Services has utilized other policy and internal procedural mechanisms to extend employment authorization to large groups of people who are in the country without legal status.
The agency has taken quiet steps to cut corners and lessen adjudicatory standards. During a transigation session period, a complete audit of agency policies, memoranda and management directives issued during the Biden administration should be completed, and rescindation signed documents should be prepared for issuance within the first few days of the incoming administration. Additionally, regulatory documents should be drafted to review or reverse all regulations promulgated during the Biden administration. New policies.
To advance the national interest, the three core immigration agencies, U.S. Citizenship and Immigration Services, Immigration and Customs Enforcement, and Customs and Border Protection, should remerge and have immigration elements outside of Department of Homeland Security included.
The fragmented immigration enforcement frame negation work that developed in the wake of the Homeland Security Act has weakened each agency and should be remediated. Combining these critical agencies would strengthen their capabilities, ensure cooperation, and promote information sharing. Agency responsibilities and the delineation of authorities, such as inconsistent use of deferred action and issuance of notice to appear by each agency, have long been a point of contention that would be addressed much more easily if they were recombined into a single entity. Alternatively, new policies for U.S. Citizenship and Immigration Services as it currently exists should focus on MAT negation tears that can be addressed through administrative action. The workforce should be realigned and, as necessary, retrained on base eligibility and fraud detection rather than speed in processing. Training should be returned to federal law enforcement training centers, which would underscore the enforcement role of U.S. Citizenship and Immigration Services as a vetting agency, and be rebranded accordingly. Management directives and policies should realign to ensure that the workforce, while adaptable and able to handle the bulk of the U.S. Citizenship and Immigration Services mission, is not allowed to be pulled off mission work to focus on unlawful programs DACA, mass parole for Afghans, Ukrainians, Venezuelans, etc., which divert resources away from nuclear family and employment programs. The regulatory agenda should include the immediate submission of notices of proposed rulemaking for the Trump administration's public charge rule, including negationing aspects from its original notice of proposed rulemaking, temporary work visa reform, employment authorization reform rules, asylum bars rule, and a third country transit rule. At a minimum, an enhanced regulatory agenda should include rules strengthening the integrity of the asylum system, parole reform, and visa reform that prioritizes relief for victims of heinous crimes and ensures that we protect the truest and most deserving victims of crime. Not all policy changes require formal rulemaking, however, as internal guidance documents are generally exempt under the Administrative Procedure Act.
In this sub-regulatory space, U.S. Citizenship and Immigration Services policy memos and operational guidance should reduce the validity of employment authorization documents and end the COVID flexibilities, including the reliance on biometrics reuse. U.S.
Citizenship and Immigration Services should also enforce existing regulations by rejecting incomplete applications and petitions, ensuring both that they are completed before accepted for filing and that Fraud Detection and National Security Directorate signs off on all approved applications and petitions before approval notices are sent to the alien or petitioner. Other efforts should be focused on adjudication standards, returning to nearly 100% interview requirements for all appropriate cases. The incoming administration should spearhead an immigration legislative agenda focused on creating a merit-based immigration system that rewards high-skilled aliens instead of the current system that favors extended family-based and luck-of-the-draw immigration. To that end, the diversity visa lottery should be repealed, chain migration should be ended while focusing on the nuclear family, and the existing employment visa program should be replaced with a system to award visas only to the best and brightest. Internal efforts to limit employment authorization should be matched by congressional action to narrow statutory eligibility to work in the United States and mitigate unfair employment competition for U.S. citizens. The oft-abused H-1B program should be transformed into an elite program through which employers are vying to bring in only the top foreign workers at the highest wages so as not to depress American opportunities. Additionally, Congress should improve the integrity of the temporary work visa programs, repeal temporary protected status designations, permanently authorize and make mandatory e-verify, and end parole abuse by legislating specific parole standards.
U.S. Citizenship and Immigration Services should make it clear that where no court jurisdiction exists, it will not honor court decisions that seek to undermine regulatory and sub-regulatory efforts. Finally, U.S. Citizenship and Immigration Services still requires access to all relevant national security and law enforcement engagement databases in the same vein as any other agency in the intelligence space.
This is a key concept that should be addressed as U.S. Citizenship and Immigration Services is returned to functioning primarily as a vetting agency. Budget.
U.S. Citizenship and Immigration Services is primarily fee-funded, operating on revenue derived by those who are seeking immigration benefits, work permits, and naturalization.
The total agency budget requested for fiscal year 2023, including both fees and a small appropriation, is slightly less than $6 billion. The bulk of funds are derived from application fees through the Immigrant Examinations Fee Account. As a general principle, adjudication of applications and petitions should be paid by applicants, not American taxpayers. It is critical that any changes in the budget, even in the wake of a realigned agency combined with Immigration and Customs Enforcement and Customs and Border Protection, should retain a fee-funded model. Given the Obama and Biden administration's lack of will, fees should be increased agency-wide to keep in step with inflation and the true cost of the adjudications. The incoming administration should immediately submit a fee rule that reflects such an increase. Aside from an increase in all fees, the rule should drastically limit the availability for fee waivers and should implement a fee for asylum applications. Additionally, Congress should allow for a 10% across-the-board increase in all fees for all fee rules to account for the fact that new fee rules always lag behind budget requirements.
U.S. Citizenship and Immigration Services should strive to increase opportunities for premium processing, a negation of it by which applicants can expedite their processing times.
While this places time burdens on adjudicators, it provides an opportunity for a significant influx of money into the agency, which is not currently available. While simply raising fees to the necessary levels to make the agency run efficiently would be prefer a negation play, without the need for expanded premium processing, this short-term measure should be utilized, particularly if longer-term fee rules are unsuccessful. At least until U.S. Citizenship and Immigration Services is caught up on all case backlogs, all applicants rejected for any benefit or status adjudication should be required to leave the U.S. immediately. Ordinary process can resume once all case backlogs have been adjudicated.
Finally, U.S. Citizenship and Immigration Services should pause the intake of applications in a benefit category when backlogs in that category become excessive.
Once U.S. Citizenship and Immigration Services adjudicators can decrease that caseload to a manageable number, application intake should resume. Personnel.
U.S. Citizenship and Immigration Services should be classified as a national security-sensitive agency, and all of its employees should be classified as holding national security-sensitive positions.
Leaks must be investigated and punished as they would be in a national security agency, and the union should be decertified. Any employees who cannot accept that change and cannot conform their behavior to the standards required by such an agency should be separated.
U.S. Citizenship and Immigration Services is
D.C. personnel presence should be skeletal, and agency employees with operational or security roles should be rotated out to offices throughout the United States. These USCIS employees should live and work in the communities that are most affected by their daily duties and decisions. Necessary border and immigration statutory, regulatory, and administrative changes. The current border security crisis was made possible by glaring loopholes in our immigration system. The result was a preventable and predictable negation-toric increase in illegal and inadmissible encounters along our southern border. This pulled limited resources from the front lines of our nation's borders and away from their national security mission, releasing a vast and complex set of threats into our country. To regain our sovereignty, integrity, and security, Congress must pass meaningful legislation to close the current loopholes and prevent future administrations from exploiting them for political gain or negation sonal ideology. Legislative proposals. Title 42 Authority in Title 8. Create an authority akin to the Title 42 Public Health Authority that has been used during the COVID-19 pandemic to expel illegal aliens across the border immediately when certain non-health conditions are met, such as loss of operational control of the border. Mandatory appropriation for border wall system infrastructure. The monies appropriated would be used to fund the construction of additional border wall systems, technology, and personnel in strategic locations in accordance with the Border Security Improvement Plan. Appropriation for port of entry infrastructure. Border security is not addressed solely by systems in between the ports of entry. Ports of entries require technology and physical upgrades as well as an influx of personnel to meet capacity demands and act as the literal gatekeepers for the country. This is the first line of defense against drug and human smuggling operations. Unaccompanied minors. Congress should repeal Section 235 of the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008, which provides numerous immigration benefits to unaccompanied alien children and only encourages more parents to send their children across the border illegally and unaccompanied. These children too often become trafficking victims, which means that the Trafficking Victims Protection Reauthorization Act has failed. If an alternative to repealing Section 235 of the Trafficking Victims Protection Reauthorization Act is necessary, the section should be amended so that all unaccompanied children, regardless of nationality, may be returned to their home countries in a safe and efficient manner. Currently, the Trafficking Victims Protection Reauthorization Act allows only children from contiguous countries, Canada and Mexico, to be returned, while every other unaccompanied minor must be placed into a lengthy process that usually results in the minor's landing in the custody of an illegal alien family member. Congress must end the Fleury Settlement Agreement by explicitly setting nationwide terms and standards for family and unaccompanied detention and housing. Such standards should focus on meeting human needs and should allow for large-scale use of temporary facilities, for example, tents. Congress should amend the Homeland Security Act and portions of the Trafficking Victims Protection Reauthorization Act to move detention of alien children expressly from the Department of Health and Human Services to Department of Homeland Security. Asylum reform. The standard for a credible fear of persecution should be raised and aligned to the standard for asylum. It should also account specifically for credibility determinations that are a key element of the asylum claim. Codify former asylum bars and third country transit rules. Congress should eliminate the particular social group protected ground as vague and overbroad or, in the alternative, provide a clear definition with parameters that at a minimum codify the holding in matter of AB that gang violence and domestic violence are not grounds for asylum. Parole reform. Congress should end the widespread abuse of parole in contravention of statute and return it to its origins as an extraordinary remedy for very limited purposes. Non-governmental organizations and processing. Congress should halt funds given to non-governmental organizations to process and transport illegal aliens into and throughout the United States. Such funds and infrastructure, including the Department of Homeland Security Joint Processing Centers, should be redirected to secure the border, detain aliens, and provide space for immigration court proceedings. Other pathways for border crossers. While Congress should use its oversight authority to ensure that expedited removal is used to the fullest extent and followed to the letter of the law, other paths for border crossers should be included in a legislative package. Migrant protection protocols. Update the statutory language providing the basis for the Remain in Mexico program as needed to withstand judicial scrutiny and executive inaction. Asylum cooperative agreements. While the agreements themselves must be negotiated, Congress should mandate that the executive branch work faithfully to negotiate and execute asylum cooperative agreements and set parameters to ensure that an unwilling executive cannot renege on an existing agreement or abandon the effort. Other expedited pathways. Congress should explicitly permit programs akin to the Prompt Asylum Claim Review and Humanitarian Asylum Review Process programs. Employment authorization. Congress should reassert control of employment authorization, which is subject to rampant regulatory abuse, and limit it to certain categories of legal immigrants and non-immigrants. Congress should also permanently authorize E-Verify and make it mandatory. State and local law enforcement. Congress should unequivocally authorize state and local law enforcement to participate in immigration and border security actions in compliance with Arizona v. United States. Congress should require compliance with immigration detainers to the maximum extent consistent with the 10th Amendment and set financial disincentives for jurisdictions that implement either official or unofficial sanctuary policies. Prosecutorial discretion. Congress should restrict the authority for prosecutorial discretion to eliminate it as a catch-all excuse for limiting immigration enforcement. Mandatory detention. Congress should eliminate ambiguous discretionary language in Title VIII that aliens may be detained and clarify that aliens shall be detained. This language, which contrasts with other shall detain language in statute, creates unhelpful ambiguity and allows the executive branch to ignore the will of Congress. Regulations. Withdraw Biden administration regulations and reissue new regulations in the following areas: credible fear, asylum jurisdiction for border crossers, public charge, T-visa and U-visa reform. Unless and until T and U visas are repealed, each program needs to be reformed to ensure that only legitimate victims of trafficking and crimes who are actively providing significant material assistance to law enforcement are eligible for spots in the queue. Repeal TPS designations. H-1B reform. Transform the program into an elite mechanism exclusively to bring in the best and brightest at the highest wages while simultaneously ensuring that workers are not being disadvantaged by the program. H-1B is a means only to supplement the U.S. economy and to keep companies competitive, not to depress U.S. labor markets artificially in certain industries. Employment authorization, along with the legislative proposal, take regulatory action to limit the classes of aliens eligible for work authorization. Executive orders. Pathways for border crossers. Direct the Department of State and the Department of Homeland Security to reinstate asylum cooperative agreements with Northern Triangle countries immediately. Recommence negotiations with Mexico to fully implement the Remain in Mexico protocols. Reinstate, to the extent possible, expedited pathways with full credible fear in immigration court process. Prohibit the use of notices to report, the use of any funds for travel into the interior of the United States, and government flights or transportation for aliens. Mandate that Immigration and Customs Enforcement use all detention space in full compliance with Section 235 of the Immigration and Nationality Act, issue weekly reports on detention capacity, and provide authority for low-level temporary capacity, for example, TETS, once permanent space is full. Eliminate the use of alternatives to detention for border crossers except in rare cases and only with the explicit authority of the Secretary. Prohibit the use of parole except in matters that are certified by the Secretary of Homeland Security as requiring action for humanitarian or significant public benefit reasons, and prohibit the use of parole in any categorical circumstance. Enforcement. Restrict prosecutorial discretion to eliminate it as a catch-all excuse for limiting immigration enforcement. Mandate the use of E-Verify for anyone doing business with the government. Designate U.S. Citizenship and Immigration Services as intelligence community adjacent, ensuring that it has access to national security and law enforcement databases. Rescind all memoranda limiting enforcement of immigration laws, including those identifying sensitive zones. And Immigration and Customs Enforcement's widespread use of termination and administrative closure of cases in immigration court. Averting or curtailing a mass migration event. Provide that whenever the Secretary of Homeland Security determines that an actual or anticipated mass migration of aliens on their way to or arriving off the coast of the U.S. presents urgent circumstances requiring an immediate federal response, the Secretary may make, subject to the approval of the President, rules and regulations prohibiting in whole or in part the introduction of persons from such countries or places as he or she shall designate in order to avert or curtail such mass migration and for such period of time as is deemed necessary, including through the expulsion of such aliens. Such rule and regulation making shall not be subject to the requirements of the Administrative Procedures Act. Provide that notwithstanding any other provision of law, when the Secretary makes such a determination and then promulgates, subject to the approval of the President, such rules and regulations, the Secretary shall have the authority to waive all legal requirements of Title VIII that the Secretary, in his or her sole discretion, determines are necessary to avert or curtail the mass migration. Subregulatory matters.
U.S. Citizenship and Immigration Services priorities and structural changes ensure that focus is returned to vetting, base eligibility of applicants, and fraud detection.
Realign the Fraud Detection and National Security Directorate to ensure agency-wide consistency on implementation of fraud detection and vetting policies. Review and repeal any internal agency memo that is inconsistent with the priorities described in this chapter. 287G Program. Issue a memo prohibiting any jurisdiction that applies from being denied access to the program unless good cause is shown. Homeland Security Investigations Priorities. Issue Department Management Directive and Immigration and Customs Enforcement Companion Directive to refocus Homeland Security investigations on immigration offenses and criminal offenses typically associated with immigration, for example, human trafficking. All criminal investigative work without a clear nexus to the border or otherwise to Title VIII should be turned over to the appropriate federal agency. Blackie's Warrants, Immigration and Customs Enforcement, Office of the Principal Legal Advisor, Enforcement and Removal Operations, and Homeland Security Investigations should issue a joint internal memo on operationalizing Blackie's Warrants for immediate use on worksite enforcement and other appropriate investigations and operations. Here ends the National Security section that was created as part of Project 2025. It is important that we pay attention and have discussions with our families. Here are the recommendations from Líderes del Futuro. 1. If you are undocumented, talk to people who can vote and have conversations with them about the importance of voting in the November 2024 elections. 2. If you are undocumented and have children who were born in the United States, make sure to have an action plan in case you are separated from your children. Create a temporary custody plan so that someone you trust can take custody of your children if you end up in immigration custody. 3. If you are undocumented, speak with a trusted lawyer to see if you qualify for a visa like the U visa if you were a victim of a crime in this country by a citizen. 4. If you are under 21 years old, single, and were abused, abandoned, or neglected by your father or mother, find out if you qualify for the Special Immigrant Juvenile Status, SIJS, visa. This could include young people who migrated to the United States and whose father, mother, or both stayed in their country of origin. 5. Pay off debts and save because it is important to have funds to cover 6 to 8 months of expenses like rent, food, and more. 6. If you have DACA, talk to trusted lawyers to see if you qualify for a visa like the H-1B visa, VAWA, or another way to obtain papers, including through marriage. It is important that we educate ourselves since we came to this country to succeed, and for this reason, we should not settle for what we have. There are ways to get an education in colleges and universities, but there are also many resources on the web that can help us. Remember that we are on KBBF.org every Thursday from 5 p.m. to 7 p.m. where we talk about immigration, education, mental health, politics, and much more. We invite you to listen from all over the planet. Thank you for being with us.